January 16th, 2025. Make a note of the time. It's 6:01. At this time, I'd like everyone to stand and do the Pledge of Allegiance. Pledge of Allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Tonight up here we have Alicia, Nancy, John, Mike, Gwen, and myself, Steve Carpentieri. At this time, I'd like to, this is going to be a training session tonight, so there'll be no public involvement. I'm going to turn it over to Stacy.
Okay, welcome everyone. So as Mr. Carpentieri mentioned, this is a training session. There is no public comment or discussion. That's not going to be allowed. The purpose of the meeting is for us to sit through the training. So just so everyone knows that. Okay, so we want to get started?
Thank you so much for having us. My name is Sarah White. I'm an attorney at the Connecticut Fair Housing Center.
I'm Rachel Podolsky. I'm an attorney with Connecticut Legal Services and work I guess what we call public policy advocate for the legal aid programs in Connecticut. And I also want to thank you for inviting us.
And just a little bit about ourselves before we get started with the training. I've worked at the Connecticut Fair Housing Center for the last 12 years, and for the last around 3 years have been focusing on fair rent commissions. Rafi and I wrote the toolkit on fair rent commissions when the law was passed expanding fair rent commissions, which includes a model ordinance. As part of that process, we looked at all of the fair rent commission ordinances and processes then in existence in the state, and developed the toolkit and have been developing FAQs as new issues arise, as more fair rent commissions have been set up. We've given versions of this training and provided technical assistance to probably dozens of municipalities at this point, and are really happy to be here with you tonight.
I've been involved with fair rent commissions going back many years. I used to be a member of the Hartford Fair Rent Commission. This was back in the 1980s. And at one point, I wrote a pamphlet on how one can present evidence to a fair rent commission. Along with Sarah, I was also involved in the law at the legislature in 2022. In the law that was passed that required larger towns to have fair rent commissions. East Lyme, being a smaller town, is not required, but you are not alone. There are a number of other small towns that have fair rent commissions. So in working with Sarah, we tried to figure out what were the kinds of questions that both commissioners themselves, the town attorneys, that the parties, landlords and tenants might have about a fair rent commission, because we knew that this is an area that's going to be unfamiliar to a lot of people. And we've done our best to try and devise ways to at least present to you and others in similar situations how we think things should be handled at the fair rent commission level, and what we think is the power and authority of the commission. So I'm going to back to Sarah. We're going to bounce back and forth with you.
So the way we're going to do the training, which is what we've done with other fair rent commissions, is we have a short PowerPoint that sort of goes over the basics of the law, how most fair rent commissions operate, the factors you can look at in making a decision. And then we like to open it up to just sort of have a discussion with Q&A to answer your questions, your thoughts, not about specific cases, but general to how the Fair Rent Commission could make decisions, how to handle different kinds of scenarios and things like that. And so with that, we'll just get started with the PowerPoint portion. And I emailed out a PDF version of this, so you all will have that to refer back to, as well as the toolkit that Rafi mentioned has, I don't know how many pages worth of FAQs, is a good resource if something comes up. So what are Fair Rent Commissions? So Fair Rent Commissions have been around for more than 50 years, but up until the last few years, were optional for towns and cities to set up. And as you know, In its most basic sense, a fair rent commission is a municipal board with the power to limit or modify rent increases or other rental charges so as to prevent them from being so excessive that they're harsh and unconscionable. And the harsh and unconscionable language is what appears in the Fair Rent Commission statute, which was passed in 1969, which is why that language feels a little bit antiquated to us. But that's, the baseline standard that the Fair Rent Commission is looking at, in making decisions about not just rent increases, but rental charges more generally. And the role of the Fair Rent Commission is incredibly important. The reality is that most tenants have no practical way to challenge an unfair rent increase, even if it's $500, $1,000, doubling rent, unless they live in a town with a Fair Rent Commission. So your role is incredibly important in giving tenants a place to go if they feel like their rent is unfair, and really the only place they have. And the idea of a Fair Rent Commission is that it functions as the conscience of the community regarding rental charges and increases. That's why, the commission is made up of, other citizens, residents of the town, and not experts. You all know, what's fair in your community. Often there's like a shared understanding of what's right, what's wrong, what's unfair, what's not, and, that's really your role as a Fair Rent Commission. Do you have anything you want to add, Rafi? All right. What else does a Fair Rent Commission do? A Fair Rent Commission can also buttress housing code enforcement or health code enforcement. So that's because you can delay or deny rent increases or even reduce rental charges if the landlord fails to maintain the property in compliance with the health or housing code. This can be incredibly important. Most of the time a landlord is going to do the right thing, is going to fix the property, but there are these situations where, even when the town has gone out, has found health code violations, has started to issue fines, the landlord is still dragging their feet on making repairs. And the Fair Rent Commission can help with that process if the tenant complains, that the rent is unfair based on an infestation, conditions in a property, can delay a rent increase, deny a rent increase, or even reduce rent until those repairs are made, which can be a really powerful incentive to fix a property. And then finally, a Fair Rent Commission can help resolve many landlord-tenant disagreements, often without a hearing. That's because sometimes the situation, at its core is that communication has broken down between the landlord and tenant. They need somewhere to go. A Fair Rent Commission can offer a place for them to talk, to work things out. It's not uncommon, for example, for a tenant to feel like a rent increase would be fair if only the stove were fixed or something like that, and to work out to get the parties to agree to make that repair and then allow it to go forward.
I think it can be helpful to commissioners to ask themselves the question: why do we have a Fair Rent Commission? What's this? When we say what is it for? I think it's important to understand, and I'm picking up on something Sarah said, which is that the role the commission is going to play is a role that's designed to help stabilize housing, to make it possible for people who might otherwise have to move to find a way that they could stay under circumstances where that's a reasonable alternative. So the very existence of Fair Rent Commissions is not to get people out, but to look for ways to keep people in. That doesn't mean it can always happen that way. There are times that when there's no decision of the commission that would allow the tenant to stay, as a practical matter. But it's something to bear in mind when you're thinking about decisions. As Sarah said, the commission's central power has to do with dealing with rent increases. Most of the cases that you're going to get are somebody complaining about a rent increase and the size of the rent increase. But as Sarah's also said, it can be what you are actually doing is looking at the fairness of the relationship between what the tenant is paying and what the tenant is getting. So, and that's one of the reasons that one role of the commission is it's not only to look at the rents, but to look at the fairness of the rents. It's why it can often hook up in connection with code enforcement, where you have properties that are not being, where code orders are not being complied with, because that creates a situation in which the property has, in a sense, been devalued, by the non-compliance, and the rental charge no longer is fair in relation to what the services are. It's important, one of the functions of a Fair Rent Commission also is to make sure that people who file complaints to the commission don't get retaliated against because they file complaints. And there are ways you can do that so that it doesn't become a situation where a tenant, if they file a complaint with the commission, is going to get evicted. You don't want that to happen, and the town doesn't want that to happen, because otherwise nobody's going to file a complaint. The Fair Rent Commission statute is broad in its authority, and as we'll talk about more as we go through and answer questions, in almost any situation that you would consider to be a landlord-tenant matter, the commission has jurisdiction to take that case and address it. So the overall structure becomes that the matters that you're going to get are initiated by a tenant complaint. There may be some opportunity to conciliate or mediate before there's a hearing, but the assumption is going to be that absent that there's going to be a hearing. You're a little bit quasi-judicial. That's to say, you're going to be making a decision on particular cases, particular complaints, and through the process, what will happen is there may ultimately be a hearing, and if you have a hearing, there will be a decision. Sarah and I bounce these questions back and forth, and so, and I'm sometimes not sure who's doing which. What can Fair Rent Commissions do? All the key words in your jurisdiction are about fairness. You're a Fair Rent Commission. You look at whether the circumstances are unconscionable, whether they're fair or whether they're equitable. Those are all words that are in the Fair Rent Commission statute. And so there are a wide range of decisions you can make. In regard to particularly the rent increases, you could decide that the proposed rent increase is sufficiently unfair. You could say no rent increase. You could say, yes, it's reasonable to have a rent increase, but this is too much. It should be a lesser increase. In certain cases, you might even have a reduction. You can make your decision fairly long term. Most ordinances, I don't know what your ordinance says, most ordinances say that a Fair Rent Commission decision will be for a year unless the commission decides in a particular case to make it for a different length of time. But you're in a position, for example, to phase things in. Like say, okay, you could have part of a rent increase now and part of it after, say, another 6 months. You could condition a rent increase on something. For example, it could be correcting code violations, or it could be making certain kinds of repairs that might not be code repairs, but nevertheless were things that were promised or expected by the tenants. You also have the power to deal with retaliatory conduct in order that it be stopped. A decision by the commission is enforceable. You're not an advisory board. And what you decide is an enforceable decision, and there are ways that it can be enforced if the parties ignore the decision. And so that's sort of kind of the basic overall on that.
I would just underscore you have a lot of power and flexibility with that power to come up with a creative solution that works for the situation at hand, and to just remember that. We've given you a menu of sort of ideas, but those aren't limited by the state statute, so you can come up with something creative that works for the situation.
Could I do one more on this?
Yeah.
What can a Fair Rent Commission consider? The Fair Rent Commission statute lists out 13 factors that a commission is supposed to consider if they're appropriate. They're not all appropriate in all cases. It doesn't say anything about how you're going to weigh those factors. And it's pretty clear from the experience of commissions that in different cases, different factors become the primary ones, either because you don't have information about some of the factors, or because some of them are so overwhelming that they're going to have, they're really going to, it almost becomes one factor is going to be so primary on the decision. The 13 factors, and you should all look at the statute, but we've kind of grouped them here into sort of 6 subgroupings, and we've sort of tried to translate them from the language of 1969 when they were written, or most of them were written, into the way we would see commissioners, and we think commissioners generally look at them. One is the size, which might be a dollar amount or a percentage, the size of a proposed increase. And also a history of past increases, which can cut either way about whether there have been, is this in a sequence of increases or not in a sequence of increases. So the size, and the size often becomes important. When you see a very large increase, that will tend to significantly influence what kind of weight you give to it. The second is what's included. Who's paying for the heat and utilities? That's something you want to know about, because that makes a difference as to what, it's not just the quote rent, but the rent. But in assessing fairness, you're gonna want to know, is the tenant having to make other payments that are not built into the rent? So that's a piece of information you'd be interested in. The third is the condition of the apartment and the complex. What is the substance of what the tenant is getting in return for the payment of rent? You're going to want to look. Now, those factors may tend to go towards the tenant. You're also going to want to look and know what the landlord's operating costs are, because that is also an important factor, because the landlord is entitled, certainly in the long run, to be able to be making some kind of a profit. The companion to that is you have the authority to look at what the tenant's income is, and what kind of alternative housing would be available if they had to move. So in that sense, it makes some difference. It may make a difference as you balance this out, how much you lean towards one party or lean towards the other. And then the last sort of general item on this are comparable rents in the neighborhood in the town. What is the rental market? But what's important to note on that is comparable rents are really essentially one of 13 factors. And so they're not necessarily decisive, but they may be helpful in you assessing what's fair and reasonable and what's not fair and reasonable. But part of what your job is to kind of figure out, under the facts of the case, how to balance those and how to decide what's primary and how to decide what would be a reasonable solution under all the circumstances. So the statute says that when you reset a rent, if you choose to reset a rent, you're supposed to reset it under the statute at an amount that is fair and equitable. And so again, all of this terminology is kind of sort of equity terminology. Okay.
I have one thing to add about comparable rents. I think sometimes, like, I've seen commissions kind of get hung up on this and think that, if, for example, other apartments in the community are now going for a certain amount, a rent increase that brings, this unit up to that amount is like automatically fair and equitable. However, that's not the case. As Rafi mentioned, comparable rents is just one of the 13 factors. You get to weigh them however you choose. And it goes back to the purpose of fair rent commissions really being about individualized rent stabilization. Going back all the way to 1969, I've looked at, the legislative hearings and, what led to this, and also the expansion of the law in 2022. And it was the legislature recognizing the harm that people face when they're, displaced from their housing because of big rent increases that price them out. How it affects that family to move out of the neighborhood, have to change schools, how it affects the neighborhood as a whole to lose people who are, vital to that community. So comparable rents is one factor, but it's not the only one. You can also look at, like we talked about, the tenant's income, where else they could go, the amount of the increase, all of these other things to, come up with a decision as a group about what's fair.
And I think you're still on.
All right, I'll do this one. So this is just sort of in general how fair rent commission complaints work. Of course, you all will have your own procedures that you follow as a town and as a commission, but generally, what the flow looks like is a tenant files a complaint. The landlord and tenant will both get notice and information about the complaint and the process. And something that's really important is that both sides understand that the last agreed upon rent is to be paid, while the complaint is being processed. And that the landlord knows, not to engage in retaliation, which is unlawful if someone files a complaint. If appropriate, town staff may arrange for a housing code or health code inspection to see what the condition of the property is, if there's any violations. There may also be an attempt by the town to conciliate the complaint. Depends on, the situation, but, some towns do have a lot of success reaching agreements in many cases, although it's always going to be specific to that case. The Fair Rent Commission has the authority to consolidate similar or overlapping complaints in the same complex or against the same landlord for a hearing. This can really come in handy when, for example, a lot of tenants have gotten a large rent increase, many of them have come to the commission, and you have the inherent authority to hear those cases together. So you're going to still be hearing from individual tenants, but would only have to hear from the landlord once. We'll only have to hear, maybe if the town has inspected it, the condition of the property once, and can consider that information together. You do need to make individualized decisions as to each tenant, but it can be more efficient for everybody involved to, consolidate those complaints for the hearing. And, just an example of how a hearing could look, again, you have discretion on how you run your hearings. You may get evidence in advance of the hearing, like a copy of the complaint, if, there are any health inspection reports. The chair will run the hearing and swear in the parties and witnesses. It's important that interpretation is provided to anyone who isn't fluent in English so they can participate. Typically, town staff and or the town attorney are on hand to provide guidance during the hearing. Parties can be represented by an attorney, don't have to be, or at the discretion of the commission can also be represented by a non-attorney advocate. And you all have discretion on what the hearing looks like, but typically each side would offer some opening statement about what it is they're seeking and why they're seeking it, and we'll hear from witnesses. Both sides should have a chance to ask questions of the witnesses, as should you. And then during the hearing itself, or at least as an open meeting, you all deliberate, come to a decision by a majority vote, and typically deliver an oral decision at the hearing. You don't have to. You could, deliberate at another time. It does, because of our open meeting laws, have to be an open meeting. You can't do it behind closed doors. But usually most commissions will make a decision at that hearing while the evidence is still fresh in their mind and they're all together. And usually staff will write up the decision after the hearing, get approval from the chair, and then send it out to the parties. Do you have anything you want to add, Rafi?
No, I don't think so.
Okay.
And we're just about done with the presentation part, okay? So, because I think everyone would like us to get to the questions. This is a chart. This is really informational for you. It's a chart or a table of the towns that have commissions. The asterisks are for towns that were required to adopt a commission because of the 2022 statute. And what I think, for your perspective, is interesting is to look all the way to the right side of that table that has non-mandatory commissions, of which there are 8. And you'll see that so none of them were required to have a commission. Most of those commissions have been around for a long time. Bloomfield, Rocky Hill, actually for quite a long time. The more recent ones, besides East Lyme, are Killingworth and I guess Wyndham would be the most recent of those, and that's within the last year or so. This chart is a rearrangement of those same commissions by region, and so if you want to get a sense of where other, for example, in eastern Connecticut, you could see southeastern East Lyme, Groton, Killingworth, New London, Norwich, and Westbrook have commissions, and then in the northeastern corner it's Colchester, Mansfield, Wyndham, and Vernon. Colchester's commission is also an old commission. So you're not alone. The commissions all have different ordinances, and so your ordinance is really what you're working from. I guess I've seen or been shown the guidelines that you're going to be working with, and I think the guidelines by and large look pretty good, and I think should work for your purposes. And you will then, as you work with them, you will figure things out. I mean, it's when something gets to the stage of the commission, in other words, when a case moves past the staff level, where there may be conciliation going on, there's a certain formality that you have to follow, because people are going to be giving testimony under oath, but it still remains essentially an informal procedure. So it's kind of hybrid. It has formal elements, but it's an informal procedure. But it's a binding procedure. You need to follow your own rules, and make sure that everybody has an opportunity to say what they need to say. But the audience, for example, does not get to take part in it. If somebody's going to testify, somebody's going to call them as a witness, and they would be sworn in like anyone else. So with that, I
Here's
think
our contact information
okay.
also. We're always happy to answer questions.
So we'll stop with that, and we're going to give this training back to you now. So we will do our best to answer any questions you have, any comments you have, any things you'd like us to talk about. I guess I want to say one thing, one that we haven't said that I think it's important to say. We've developed, we spent a lot of our own time and tried to develop additional expertise in how Fair Rent Commissions work. We are not, however, authorized by any particular entity other than the people we work for to be doing this. We're not like a State Department or state agency that is saying to you, this is what you must do. What we're saying is, this is what we think you ought to do. And so I don't want there to be confusion that makes it look like we are laying down a set of rules for you, because we have no authority to do that. What we bring to you is our own knowledge and perspective as to how Fair Rent Commission can best work. And so I just want to say that it's like a disclaimer I want to give you, because I don't want us to be misrepresenting what our role here is. So I don't know how you want to run this, if you want to call on people, or you want us to call on people, or people just want to say something. We'll respond.
Well, I have a question. I just want to get clarity. Can a tenant submit a complaint before they even receive an official increase?
So yeah, so your jurisdiction is actually over rental charges, not just rental increases. And rental charges is defined in the state statute and includes both your base rent and anything else you have to pay to live there. So I know increasingly we see these like holdover fees, month-to-month fees, adding other fees. All of that gets treated as a rental charge. So you are actually hearing complaints about rental charges. Most of the time that is going to be about a rent increase, but people do have the ability to complain about, the rental charge itself. And often then you're going to be looking at what's the condition of the property. Has there been a reduction in services? I mean, something I've seen a lot is like people, for accessibility reasons needed an elevator, the elevator breaks, they're no longer getting what they paid for, that could trigger a Fair Rent Commission complaint.
I guess I also want to say something about the way you phrased the question, because commissions can hear a case both before a rent increase has taken effect or after.
Okay.
But it's clearly best, it's much easier to deal with if people file complaints before the rent increase is supposed to take effect. And it's important to remember that until a rent increase takes effect and the tenant agrees to it, it's a proposed rent increase. Well, all the time, I mean, I deal with tenants who say, my landlord raised the rent. Landlords can't raise the rent unilaterally. People have to agree. It's like if you go to buy a car and they say, here's the sticker price. You wouldn't say, you can bargain that if you want. So landlord-tenant law is the same way. What you're looking at, until there's an agreement, is a proposed increase. And it's one of the reasons that we recommend that if somebody says, well, what am I supposed to pay while I'm waiting for your decision? People should be paying the old rent, not the new rent, because the new rent hasn't gone into effect yet. Why hasn't it gone into effect? Well, by the very act of coming to the commission, the tenant is saying, I don't agree to this. If you don't have an agreement, then you don't have a rent, you have a proposed rent. And so I think you need to think of it that way. It sometimes happens that tenants either don't know there's a commission or feel very intimidated and will may sign a lease or may for a month pay an increase thinking that they don't have a choice. And I think the policy of most commissions is that doesn't mean you can't file a complaint. At some point down the road, it may not be it's not going to be reasonable to try and sort of after the fact that where you've already agreed to something, now to change your mind. But that may influence how you handle a case that comes in like that. But certainly, certainly when cases come in where the increase is not yet taken effect, or is just taken effect, remember, it's not going to take effect at all if the tenant never agrees to it. So the answer to your basic question is, oh, I've lost your question. I think the answer is yes.
Well, I just wanted, because I wanted to get clarity. For example, if I was paying, I don't know, $1,000 for my rent, but I hear that my rent's going to go up to, I don't know, $1,500. I haven't officially gotten that number from the landlord. It's hearsay. So can I still, or does it make sense to put in the complaint before I even get the official increase from the landlord?
The official is a funny word because there's nothing makes a proposed rent increase official.
Mm-hmm.
It seems to me you need some reason to believe that a rent increase in a particular amount is coming.
Mm-hmm.
I would say, I don't know if Sarah agrees with this or not, but I would say if it's a fear of a rent increase, but there's no rent increase that's been proposed, I think it's very premature for somebody to file a complaint. But once once the landlord says your rent is going up,
Mm-hmm.
You can't really take it back. In terms of the jurisdiction of the commission, once the rent increase has been identified, you're going to have jurisdiction to address that.
And that could be in any form. That could be a phone call where the landlord says the rent's going up. That would, that's a rent increase, or I'm like complaining to raise the rent. It could be a letter, but it doesn't have to be a letter or like a formal seeming notice.
Right, but there, I think there has to be, if the basis for the complaint is a rent increase, the basis might be something else. But if the basis, there has to be some degree of expression as to what that is. Here's what you want to watch out for and you want to avoid. Mm-hmm. And I'll give you an example of a situation. Landlord says to the tenant, when your lease expires, your rent's going to go up by X number of dollars. And the tenant now says, well, I don't agree with that. I'm not going to pay it. And the landlord says, oh, fine. I withdraw my proposal, and now I'm going to evict you at the end of your lease. That is why it is important to recognize that is not a successful evasion of the Fair Rent Commission. The argument then gets made. The tenant files a complaint about the rent increase that they have actually rejected, and the landlord says, "Oh, I'm so sorry. I'm not going to. I just don't want that tenant here anymore." The tenant then files a complaint. You say, "Well, that's not." One could say, "Well, that's not retaliating for filing the complaint. Mm-hmm. It's retaliating because the tenant is going to file a complaint, and once the tenant does, if the landlord continues to refuse to moderate, then you'll have jurisdiction. In the end, you might decide the rent increase was not unfair. It doesn't mean the tenant's going to win, but it is important because otherwise you create a retaliation situation that's where the message to the tenant is once that you can avoid, almost like a race to the courthouse, and you don't want that to happen. So I think the question is very important in terms of the timing. But there is I don't think you can complain just because you've heard rumors going around that there are going to be rent increases.
Okay, that's
you
fine.
really have to wait.
What happens, in her case, what happens if, say, she hears a half a dozen tenants in that same building, they're all getting rent increases? Does she still have that opportunity to file a complaint, knowing that it appears that it's coming?
Hypothetically, there could be a situation where the landlord has communicated that everyone's rent is going up.
Yeah, they just haven't got to her
And
yet.
so where it's not a rumor, it's credible, it's based on, maybe some sort of communication that has been made generally to all tenants or to the public, I don't know. And I think in that situation, someone could file a Fair Rent Commission complaint, even if it hasn't been directly communicated to that tenant, your rent is going up by this, certain amount.
Okay.
And that's not uncommon either, where something is communicated by one means or another, but it's generally communicated that this is happening for everybody in the complex.
Okay. Thank you.
Just a thought from a landlord perspective, because we're going both ways. A tenant's rent is $1,000. hypothetically. The utilities are all paid for as part of the rent, so there's no extra cost. The electric bill goes up $100 a month per unit. I newly buy this facility. It's 25 years old. It needs painting. It needs repairs, new gutters. So I'm going to say I need $100. I need $200 more, and the mill rate goes up another bit, so there's another $50. So now he says I want $1,600. There's a fairness that has to be examined there, that there is a cost of doing business versus a cost of paying your rent. So those are all bona fide considerations to put into the decision-making process.
Absolutely, absolutely. It's one of the reasons I think in some cases a commission may look at phase-in over time. That they might say, well, the landlord's got these costs, and the landlord's going to be entitled really to ultimately, in any event, recover those costs. On the other hand, this has a very negative impact because it's so large, and that may lead to a decision that says phase in as a solution. Okay. One of the things I guess I want to say, a lot of the problems that drove the new statute, that led to mandating, I mean, it's sort of unusual. I mean, fair rent commissions were something that were allowed to towns, but now for the larger towns, it's mandated on those towns, and a lot of that was driven by new property owners purchasing properties relatively inexpensively, sometimes older properties, sometimes properties from a landlord who didn't have a mortgage anymore, and then seeing them as a significant profit source, and seeing the market as being higher, and immediately jumping the rents to the market. And that was, in some extent, that was a driving force for doubling the number of fair rent commissions in the state. And what it's important to recognize is that especially when you have a new owner buying a property, they buy the property knowing what the laws of the state of Connecticut are, and what the rents are, and what they are getting when they buy. So it's not like someone can say, well, I had no idea that the rents were low and so much below what I feel I need on an ongoing basis. So, of course I'm going to jump the rents, because you may determine that's not fair under the circumstances of the case. But part of the logic of that is, presumably, a person buying a building knows whether it's occupied or not, knows whether there are existing tenants in it, may know if some of those tenants have been there for a long time, living there for much of their life, and know what the rental market is. And so they buy it knowing knowing ultimately that Connecticut law allows towns to have fair rent commissions, and may know that in fact that your town does have a fair rent commission. They have to factor that in and say, do I still want to buy this? Do I want to pay the price I'm going to pay? So it seems to me there's an assumption that a new owner takes the property knowing, for example, they might not be able to get a $500 rent increase right away. They shouldn't be surprised, because they know that the town has a fair rent commission, and in that town there's a government entity that has the power to say this is unfair. So it's not, you may have people saying, well, they're really surprised. They wouldn't have paid what they paid for the property if they knew this. But to me, that shouldn't be a surprise. Now, it doesn't answer the question of fairness or unfairness. As you said, all of these factors are legitimate and can be weighed. And certainly the cost is a significant factor from the landlord's perspective.
Just one thing to add on operating costs. It's within the power of the commission, or you can ask the landlord for evidence as to operating costs. Break down how much is due to, like, what the actual property tax increase might be, the utilities, what they're looking at as profit. I know Rafi has experience from the Hartford Fair Rent Commission with the type of evidence they asked for back then.
Yeah, I mean, it's reasonable for you to expect the property owner, if the property owner says all I'm doing is covering my costs and a small profit. I mean, you should expect from that property owner an operating statement that shows you, so you can look at it. But you may have the same situation with the tenant. A tenant says, I can't afford this apartment, and they want you to lower the rent because it's not affordable to them. You're entitled to say, well, I need to know what your income is, because I mean, that's relevant information. And it's legitimate for you to want to do that. You have subpoena powers. You could actually subpoena this. My suggestion to commissions, and this is my experience at least in long ago days when I was on a commission, was the commission did not subpoena evidence that the parties didn't produce for them. But the commission essentially assumed that the party who didn't submit evidence that it had does not believe that is a ground for their position. In other words, if the tenant is not going to give you any information about their income, then you're not going to say, well, this is unaffordable to you, because you don't know what the tenant's income is. But that doesn't mean the tenant loses. There's still 12 other factors to look at. And by the same token, if the landlord says, I'm not going to, my operating expenses are none of your business, I'm not giving it to you, you could subpoena that and require it. Or you could just say, well, I'm going to assume for purposes of this decision that you do not need this rent increase for you to be able to maintain the cost of the building, because you're not offering us any evidence. We'll assume that that's not your reason. Could the landlord still argue in favor of the increase? Yes, because again, it's one of the factors, but there are other factors, and so how the other factors play out might make a difference. But I think for at least some commissions, it's fairly routine to suggest that the landlord should, because of the assumption that probably the landlord is going to argue that they need the money to produce something that shows that. But assuming they do produce it, and assuming even that it shows it, especially in the case of new owners, that doesn't mean that you have to approve the rent increase, because you have other factors to consider, and you have other kinds, and there are options, and there are various intermediate positions. But yes, on all that.
Further on that. So we would obviously ask them to bring the operating statements to the hearing, correct?
Yeah.
Yeah, you could, I think it makes sense for a commission to suggest to both parties what information might be helpful.
Okay.
It's not like that's not a subpoena. I mean, you don't have to bring it, but but I think it's certainly fair to tell a landlord that if they're objecting on the basis that they need the money to bring a statement. One of the things I learned, this is my big evaluation lesson that I learned from being on the commission, was that landlords often claim as an expense a particular item that is not an expense, which is depreciation. Depreciation is not an operating expense of the building. It is something that will ultimately come into play somewhere down the road for tax purposes, and become something that's applied in an annual examination of profit and loss. But it's not an expenditure. It's not an out-of-pocket expenditure. And so one of the things I discovered was that how you look at an item called depreciation makes a difference as to whether it looks like a property is running at a profit or a loss. And so you need to apply some judgment to an operating statement as to what makes a difference to you in terms of if you're trying to see to what extent this is necessary. It certainly makes a difference also what the money's going to go for. I mean, there's nothing that says a landlord cannot argue that they need the money in order to make certain kind of repairs, but it may be that you should be looking at those as capital repairs, not as repairs you're getting back all at once. Or again, it plays into the phase-in question. If you were to do a phase-in, you really control how long that phase-in period is going to be. Sometimes the commission comes to the conclusion that you need a phase-in of this longer than you would likely have the lease for. There ought to be a 3-year phase-in or a 4-year phase-in, not a 1 year, and you're not really prepared to say that your decision is going to go for more than a year. And so what you might do, your decision might have the first stages of the phase-in, but it's only going to go for a year, but you don't have the complete phase-in. What happens then? Well, your decision ends after a year, But if the landlord moves ahead with further increase, the tenant is free to come back with another complaint, and you'll consider that at that time. I mean, that's, again, it's your capacity to be flexible is pretty broad, in our opinion.
A decision doesn't have to be limited for a year either. I think that's just become kind of customary, but there's nothing in the state law that says it has to be a year.
Right, that's true.
Are there any special circumstances? I thought I read something in the toolkit about age, disability, things of that nature on the tenant side.
Yeah, this is really interesting because you actually have authority to enforce a different landlord-tenant statute that's not in the Fair Rent Commission Act is in Title VII of the statutes. The landlord-tenant laws are in Title 47A. If you look at the statute, you will see that it authorizes you to enforce 47A-23C, which they sometimes call the just cause eviction statute. But it's not merely an eviction statute, and it's not exactly just cause, but that's sort of the short term for it. And that statute provides special protections for renters who live in buildings or complexes of 5 or more units, if they are either elderly, and that's defined as over 62 and older, or disabled, which is designed is a disability that's going to last at least a year, sort of a Social Security disability kind of standard. And it says in that statute that we know any tenant could apply to Fair Rent Commission, but it says if those tenants are in a town that don't have a Fair Rent Commission, they can actually make their fair rent complaint in court. Other tenants can't. But if you're elderly or disabled and live in a building with 5 or more units, if you live in a town with a Fair Rent Commission, and this is where the overlap now comes, it says that the rent must be fair and equitable. And that is technically different from so excessive as to be harsh and unconscionable. So in your response to your question, is there something that you might do a little differently? That for a tenant that is living in a building or complex with 5 or more units and is elderly or disabled, then your assessment is this increase fair and equitable or not? That it's an interesting question as to what extent is fair and equitable different from so excessive as to be harsh and unconscionable. And it's not clear if there's any difference at all. But your statute says that if you determine, in general, now for any tenant, that a rent is so excessive as to be harsh and unconscionable, your authority is to reset it to an amount that is fair and equitable. But for that protected category of tenants, they sort of go to that second, you go directly to that second stage. That's to say, you don't have to talk about so excessive as to be harsh and unconscionable. For them, you go right to fair and equitable. But I think people feel to a large extent that what makes something so excessive as to be harsh and unconscionable is that it is not fair and equitable. And so there's a sense in those two phrases merging into being something akin, maybe not exactly, not literally the same phrase, but fairly similar.
I think they are fairly similar, but it's also, I think, fair for you as the commission to sort of think about, harsh and unconscionable versus fair and equitable and give them their own ordinary meaning, or like a meaning that makes sense to you all. I think it's possible that harsh and unconscionable, crossing that threshold, is a little bit tougher than just assessing whether a rent increase is fair and equitable, which is what you look at for those elderly or disabled tenants in the bigger complexes. But
I think it may also reinforce something about the kind of the protective nature of the statute when we talked about stabilization of housing. In some sense, when you take those two statutes together, it's kind of a message to the commission that we really don't want seniors to lose, and people with disabilities to lose their housing because of large rent increases. Maybe even not just large, but larger than are needed. And I don't know to what extent, if any, that makes a difference, but it sort of plays into that factor of the tenant's income and the availability of alternatives. There's sort of an implicit recognition that there's some people for whom it is especially difficult to move if changes in the rent are going to end up forcing them to move.
And that goes to the other piece of that just cause law that Rafi was mentioning, which gets much more attention, which is for renters that are protected by the elderly and disabled. A landlord can't evict them just because their lease is up or because they're a month-to-month tenant and they haven't done something wrong. There has to be, a reason for the landlord to evict them that falls within that statute, which again goes back to the idea that for elderly and disabled tenants, they are more vulnerable. The consequences to them can be, more dire if they have to move.
Thank you.
I have a question. The hearings, the discussion, deliberation of the board is open and to the public. There's laws in Connecticut called the Freedom of Information. And for example, there may be information that is given either by the owner of the property, which might be the reasons for their entrepreneurial model that they created, or certainly for the individual that may have a disability but may not want to say what that disability is, to their income stream, to anything like that. If they bring that information to the board, is that now waiving their rights to that freedom, to protecting that information? And does the board have to give any special consideration to that?
I think that if you were, I think the question of deliberating in public is different from the question of to what extent the public has a right to the information that you've received. So there may be, I don't know that there's been a resolution of that issue. The openness of the deliberation was sort of tested in the 1990s. Someone filed a complaint with the Freedom of Information Commission, which determined that the mere fact that you might be getting some information that people would like to be kept confidential did not allow you to close the meeting. And even if you did close it, you would only be able to close it for a limited purpose. I don't know. I think that if you were, I think that information, for example, something like somebody's income, an individual's income, that if someone was trying to obtain that information through the Freedom of Information Act, I think you might well be entitled not to have to disclose it. So I don't know that that's come up actually as a direct issue. The issue that's come up more often has been can you deliberate in closed session? And that's the question that seemed to be answered by a number of years ago, and the answer was no, the deliberation is supposed to be an open session.
Yeah, I'm looking more from it, is it a deterrent? If somebody doesn't want their income to be publicized, if you will, or made aware in a public meeting, their rent is going up, they have their reasons why they don't want to give that information.
I think
You may be disabled under VA or some other form that you don't want to give out that information.
So I would say, for one, I think partially it's a question for the town attorney, who's more of an expert in the freedom of information laws and the public meeting laws than Rafi and I are. But I also think that there are some practical considerations to think of in terms of access to that information. So if you're doing just a public meeting like this that's not being posted to YouTube, it's going to be a lot more work for someone to have to request a recording of the hearing, try to get that information. So there's some level of protection there that it's not just being published on the internet or freely available for people to see. And I think then also thinking about how you're asking questions or what kind of information is being elicited during the hearing to try to avoid getting too much sensitive information. So I think particularly with disability, most of the time you're not going to need to know the details, right? So if someone receives SSI or SSDI, they've been determined by the federal government to have a permanent disability. That's an incredibly onerous process. You probably don't need to know anything more unless it's like directly relevant to their circumstances. For example, if they're in a wheelchair and need an accessible unit, and that makes it even more, challenging for them to move somewhere else. Otherwise, you probably don't, you certainly don't need medical information, if, for example, the landlord or landlord's attorney was trying to get that information from someone, that might be a moment to intervene, but, can limit what you ask for around that. I think income is similar. You may need to know someone's income if they're, relying on that as an argument for why the rent increase should not go forward, but, you don't need to necessarily see pay stubs or anything like that, or can have something, submitted in writing and try to limit how much is collected.
I do think I think it's an excellent question that you ask, and there is a dilemma around it. But for information that is basically is what the decision is about, that you have to have, and presumably is presented in an open session. Part of it is, if you really were going to do that, you would end up taking the whole case into executive session. In other words, because for example, if the tenant's going to testify as to their income, and the argument is, well, your income is secret and it's protected, well then the tenant can't testify to that at an open hearing. But if the tenant wants the relief that they're asking for, they're going to have to decide whether they're willing to say at the hearing, to answer questions from you. It's kind of a dilemma, because it does mean, I think, that it generates a situation that because the information is an essential part of the information gathering process that you need to make a decision, it sort of loses its confidential character to some extent. And I think that was the reasoning behind the notion that you have to deliberate in public. That the information, it's different than an entity filing an application with the state agency where they disclose financials.
Yeah, in fairness and equity, I just don't want it to be a deterrent that somebody,
Yeah, and we don't either. But I think the at least for purposes of the hearing itself and the deliberation, that the discussion that involves it and the testimony that you get about it is expected to be done in open session. So there may be a separate. It's probably worth our trying to explore for our purposes. If that changes in any way, if somebody requests the information from you, and it may be that there's a different answer if the information is requested, as distinct from what's happening at the time. One of the things that I would just mention, just because sort of the discussion aspect came up, one of the questions that happens with commissions is, when do they make a decision? You have what amounts to a hearing at which people testify, and then you've got to discuss and decide what your resolution of that's going to be. There are some commissions, I believe, that don't do them at the same meeting. That they say, okay, we'll come back in a month. When our next meeting, we'll deliberate the decision. I strongly advise you against that. People forget over time what they heard, and they misremember or don't remember. And that our recommendation is, if at all possible, do the testimony part of the hearing, and then as soon as that's done, close the taking of testimony and move to the deliberation portion of your meeting. If you had more than one case, you might do all the testimony from everybody first, from multiple cases, and then do deliberation. But assuming that these are separate cases, different people, different landlords, I would do testimony, deliberation on case one, then testimony, deliberation on case two. And that way you don't mix up in your mind the different people that you may have heard from in the first case. it's, I really worry about the commissions that delay the decision to a future meeting. Plus, it's very inconvenient for both parties, because then they don't know your decision yet. I mean, when you do it all on the same day, they leave knowing the decision. You may not, they won't have a written decision yet, because somebody's got to write it up, but they'll know what the decision is if they stay and listen. And that will, from both their perspective, it will then answer the question, what rent do I pay next month? Because now you've decided, and your decision might be you start paying the rent increase now, or it might be you start paying some lesser amount, or that you get to keep the old rent. Whatever your decision is, it's now determined, and they know what to do the next first of the next month.
And I would just add on the decisions, I mean, again, you have a lot of flexibility, and often what this looks like is, discussion, proposing different things, kind of seeing what there's some level of agreement around. It does only have to be a majority decision, but the reality is that for most decisions, or for most commissions and most decisions, like, there is a consensus of everybody, although there doesn't have to be.
I mean, historically, it's been interesting that commissions are able to come to a decision that the whole commission feels comfortable with. Most decisions by commissions are unanimous. Not all, but most. But ultimately, it's a majority vote of the members of the commission.
Can I have a town attorney comment? Catherine Marion here for Tracy Collins, who had a family emergency. I think that Stacy can maybe report, your first public hearing will be a multiple.
Well, that was one of my questions that I wanted to ask. So we have 12 cases are with one landlord and one property. 10 of them actually are represented by Connecticut Fair Housing Center. 2 are not represented. So for our first hearing, my question is, do we schedule all of them because it's one landlord?
Well, my advice would be you schedule. Is it the same? Are the dollar amount increases different, or are they all the same?
They're pretty much.
Okay. I mean, if I were the commission, I would schedule them all for one hearing.
Okay.
There's no right or wrong here, but it seems like administratively the easiest thing to do would be to schedule all for one hearing, to determine whether there is anyone. So the landlord is probably going to have identical or similar testimony from the landlord's perspective on all of the complaints. So you don't need to have, so the landlord would be able to testify once to everything, all the 12 units. The tenants, I would say, should be asked to what extent they could present, somebody could present the common aspects for all of them. So that you could approach it as, now the tenants may not be willing to do that. I mean, I don't know. But if that's something that you would get from one witness testimony about the things that apply to all 12 units, you would also need to say to the tenants, do any of you want to speak specifically about your own unit, because your own situation, because they may not be identical. But in the end, you're then able to make, so technically you're making 12 decisions, but it may well turn out the 12 decisions will all be the same, because in the commission's weighing and balancing the factors, it may turn out that the factors that are most important are the factors that overlay all of the complaints. The commission could decide that there are reasons why some of the cases should have a different result than the others. Might be because of the condition of the premises or something like that. But I think that makes it more manageable. If there's a reasonable way that without having every tenant testify to essentially the same thing, that you can get that into one witness, I think that's going to make it easier for you. To come back, I mean, if you literally went, I mean, it's going to take you a long time if you do it as 12 separate hearings, and it may mean you have to spread it out over a longer period of time. So, I mean, I would do it is consolidated.
What you're
And yeah, and I mean, it's tricky, it's really unfortunate to have that issue like your first hearing, because, you know, of necessity, the first few hearings that you do, you're gonna be figuring out for yourself, how do we conduct this? What are the questions that are most important? I mean, you may not know right off the bat what questions you wanna ask from either the tenant or the landlord, until you've made a couple of decisions, and during the course of making the decisions, you realize, I wish that we'd asked, you know, these questions, and you'll know for the first time. Or in some case, I mean, you do have the authority in the middle of deliberation to decide that at least if the parties are still there, that you want to reopen the evidence taking because there's something that now you realize is really important to you, and we never bothered to ask that question. You can. That's kind of disruptive. It slows things down. It can cause some confusion. But it's not impossible if that was something that you wanted to do. But it's too bad that your first couple of hearings are not like really simple, clean ones, and you can get a lot of practice in, and then you deal with the more complicated one. But you have to do what you get. I mean, the complaints come in, you have to deal with the complaints.
In my opinion,
that'd be my suggestion.
In my opinion, if we have 12 people all from the same complex and one landlord, I think it would make sense to do it all at once.
Yeah.
If they have
Absolutely.
one person who wants to speak on behalf of them, or even a couple people for maybe a couple different issues that are there, it would make more sense to do it that way, because it's going to be uniform, it's going to be one decision based on that landlord and that building.
Yeah, I think that's right. I mean, one way you can
That's
do
just
that.
my opinion.
One way you can do that I mean, you can if you want. If you're doing it that way, you could, having taken sort of the general testimony, you could say, is there any tenant who wants to speak as to their particular conditions, but please speak to what's individual about you. If it's already been spoken about by the person who is kind of speaking for everyone.
Well, I'm assuming they're all going to speak themselves, and they're going to have an idea already what's going on.
10 of them have an attorney, the same attorney.
So
So-
that attorney's probably going to be doing the speaking.
And he'll offer a summarization, rent from here to here, and cover the bases for each of the 10, yeah.
Yeah,
Okay.
hopefully if attorneys are involved, and this is whether it's for the landlord or for the tenant, that they will effectively help you in the management of the hearing. And so, for example, an attorney who's representing 10 of them might be the one who figures out who they would like to have be their primary witness, and so that makes it a lot easier for you, because then you don't have to try and get the tenants to figure that out themselves, and it can be presented in a coherent way. You know, the other two tenants may be willing to agree that they'll sort of go with what the other 10 are doing, or they may say they want to be able to do their own speaking, and that's okay too. I mean, that's it. You want to give people a chance to say what they want to say, but you still are managing this process. And I mean, there's a time when you can say this is redundant, and we already have this evidence in, but to me, one of the issues that has sometimes come up is are the parties allowed to cross-examine each other? And I think the answer is yes, because that's sort of a due process rule. But to me, the most important part of the questioning is the questioning that's done by the commissioners, because you know what you need, or you will figure out what information you need to be able to make up your own mind and figure out what you think is the right decision. And if the parties don't adequately present that information to you, and that may very much happen when there are no lawyers involved, or one side has no lawyer, the other side might, but where the parties, as self-represented as pro se complainants, they don't always know what you want to hear. I mean, they don't know what you need. And so I think one of the important roles of the commission especially with the party, landlord or tenant, who doesn't have a lawyer, is you want to be able to ask them questions, because you need a certain kind of information, they haven't addressed it. Their answer may be they don't know, and that's fine. But you might want to ask them if you think it's important to you. So that questioning part, I think, is a very important part. I mean, it supplements the basic testimony, but it'll help you a lot so that you don't go into deliberation feeling that you just don't have enough information to make a decision because people didn't bother to give you enough information, probably because they didn't understand what they were supposed to do.
I just have two questions. One of them was, what happens if either party doesn't show up, whether it be the landlord or the tenant? Does it sway anything in the hearing, or we just proceed, I guess, regularly?
You can proceed.
Yeah.
As long as both sides had notice of the hearing, if someone chooses not to show up, you can still go forward. I mean, you also have the discretion to give them a call to see if something happened, to delay the hearing. It's up to you how you want to handle it, but you can certainly go forward with the hearing. The tenant does still need to present their case. You would still weigh the factors. It doesn't mean the tenant wins, automatically, but the landlord, if the landlord is not showing up, is what we usually see, then they've probably, waived their chance to argue that the rent increase was, due to their operating costs or things like that.
Yeah, if the tenant, I don't think a tenant can win a case if they don't show up. I mean, because you need some evidence. I mean, somebody's got to say something. So a tenant not showing, either you're going to dismiss it or you're going to reschedule it. And certainly if you think that there was some misunderstanding or something like that, then you want to reschedule. If the tenant shows up but the landlord doesn't, then you're in a position to go forward with the case anyway and make a decision. And you're going to make a decision based on whether the tenant has convinced you. Obviously, the landlord is essentially waiving the opportunity. If you have reason to believe that there was some good reason for the landlord not coming, again, then maybe you could continue it to a different day. But where it's the landlord that doesn't show, you're in a position to hold the hearing because you're going to get the information. You'll get the information you need from the tenant. If it's the tenant who doesn't show, then there's nobody to present the case for the tenant. You really can't.
No case.
Right.
There's no case. It's the only thing you could do is either postpone or dismiss.
And just to clarify my second question, so when we meet again on the 29th as a hearing, would that be the first time that we are presented with the complaints?
That's one of my questions.
Okay. Or are we deciding if we're going to meet as a commission before that, so we can kind of get a heads up of what we're walking into?
You can't meet as a commission except in public, but you can
Well,
get a copy
sorry.
of the complaint, like a
Okay.
packet to review. And again, different commissions handle this stuff differently. I think it's very helpful to have read through the complaint and be able to familiarize with yourself, and you can jot down questions you'd like to ask and be thinking about, what you want to know. So ideally have the complaint beforehand. If there's any health or building inspection reports, anything in writing that you already have, that the town already has, or if the parties have submitted it, that's up to the town how they want to handle it, to get that to you in advance so you can look through the packet and start to familiarize yourself with it.
Okay, so I'll be sending the notices out tomorrow for the hearings on the 29th. And I did actually try to conciliate with the parties earlier this week. It wasn't successful. But they're supposed to be sending me over information, leases and things that I don't have in the files. Now, do I provide those to the commission ahead of time? Do I provide that to the other party?
Yeah, well, I want to hear what you're going to say.
I mean, I think ideally, it's up to you all how to handle it. But at least for myself, I know that I prefer, it takes me a little time to absorb written documents. So I think providing it to the commission and also to the other side is fair.
Okay,
Yeah.
that's what I thought.
I think that's fine.
Okay, okay.
So it's a good disclosure
Great.
to everyone. The question to follow up on some of this, pre-hearing and the hearing. Now, if she negotiates with the landlord and the tenant, you're the point person, and they agree okay, we're gonna raise rent $100, period, we're done, we both agree. Does that come to the commission to rubber stamp and then send out the letter of designation or decision?
I think it should.
Okay.
There are really two ways to deal with it. One is you've got an agreement. The tenant could withdraw the complaint or the equivalent of that. But there's a risk that a tenant would not benefit from the protections. I mean, the statute gives anti-retaliation protections for people who file complaints. Withdrawing the complaint may raise a question about whether that protection is still going to be there. So
Okay.
I think it's probably preferable that the commission, the parties wouldn't even have to be there for this if they didn't want to.
Right.
The commission would simply accept it and make it a decision of the commission.
Right.
And that would help its long-term affordability. I mean, what happens if down the road one of the parties doesn't comply with it? If it's been to become a decision of the commission, then it's
Right.
presumably an enforceable decision. I don't know that commissions all do that. In fact, I don't know for sure if any commissions do it that way.
Makes sense, though.
It makes sense.
Yeah.
But it makes sense. But I think it's also I think it's not uncommon to do it the other way, which is simply that the complaint gets withdrawn. But probably better to have something something in it, particularly if it's a decision that reflects that reflects what the landlord is agreeing to do.
Mhm.
I mean that. If for example, you have the parties agree on what the rent's going to be, and then the tenant doesn't pay the rent, well, the landlord's remedy is going to be to bring an eviction for non-payment of rent. The landlord's not going to come back to you on that. Where if the landlord doesn't follow their own the agreement, the tenant's going to want to come back to you. So it's another reason it makes sense for you to sort of adopt the agreement as your decision.
I think either way, it's incredibly important that that agreement be in writing, is signed by everybody. Everybody understands what's going to happen. So if there is a problem, there's a clear paper trail as to what the agreement was, and that it came out of something filed at the Fair Rent Commission, so that tenant is also protected from retaliation.
In part two of my question, I didn't mention this, is we're at the hearing, the initial, it's a no-go, we go to the hearing. Halfway through the hearing, somebody falls on their knees and says, okay, I'll lower the rent to this and only raise it this much. Let's withdraw this and let's all agree. So at that time, we can terminate this and indicate in a summary statement for our decision that the decision of the owner is this, the tenants agree, therefore we render no further decision, period.
Yes.
Okay, you can do that. I think it would be better
Okay?
to say the landlord and the tenant have agreed to the following. We ratify that by adopting it as the order of the commission.
Okay.
So now it's become a commission decision. It's moved from being a private agreement between the parties to an official decision, which the parties have agreed to. I mean,
Right.
they've agreed not to put on any evidence. They've just agreed to that. So I think that gives both parties more security in terms of if people change their minds later on.
I would say fundamentally, though, at any time the parties can reach an agreement. That could be, you would like that to happen early after the complaint is filed, but it could happen at the hearing. I think the example we as lawyers know is when the judge, tells you to just talk to the person in the back of the hall, which can be frustrating because you shouldn't be afraid to make a decision, and I don't think you all will be. But certainly the landlord and the tenant could agree at the hearing, in the middle of the hearing, and
Sure.
to reach some sort of.
So this is my last question of the night, I promise. But if they, if the tenant puts in the complaint, and let's say obviously, the landlord gets notice that hey, the tenant has submitted the complaint. At that point, the landlord can have like a come to Jesus moment and say, "We're gonna lower your rent." At that point, does the tenant have to let us know that they privately spoke to the landlord, or the landlord's trying to make this work now without coming or proceeding with the rest of this period?
So you're saying that before the hearing,
Mm-hmm.
after filing the complaint, but
Mhm.
before the hearing,
Yep.
the land, and not through some conciliation, they just talk to each other,
Mm-hmm.
and they've worked out an agreement.
Mm-hmm.
Yeah, I mean, either of those, the option of withdrawing the complaint
Mhm.
is okay. It's important, one of the things I think is important is the complaint be filed.
Mhm.
I mean, I looked at some of the guidelines and made a suggestion on them, that encouraging the parties to work out their own agreement is perfectly fine. And if that leads to withdrawal, that's okay too.
Okay.
What's important though is that if someone comes to the commission and wants to file a complaint, that what they should be told is not, why don't you talk to your landlord, and if you still have a problem, come back.
Right.
What they should be told is, file your complaint, but why don't you go and talk to your landlord and see if you can't work this out before the hearing. The difference is that the filing of the complaint is going to provide a protection against retaliation. The failure to file the complaint is going to lead to make it much, much harder for the tenant to be able to establish that they were retaliated against, because you can't say that you're retaliated against because I filed a complaint. You didn't file a complaint.
Mm-hmm.
So the filing of the complaint becomes significant. But self-negotiation, I mean, between the two parties, that's fine. And if what that leads to is a withdrawal, that's fine.
I would say, though, going back to it, like, make sure, that something is in writing. If a tenant is just calling saying, I want to withdraw the complaint,
Right.
and not providing any other information, asking and, maybe offering to reduce it to writing and have it signed, or, adopt it as the order of the commission, reached by the agreement of the parties, so that there is that paper trail, and, the commission is available in the event that, maybe either side doesn't follow what they agreed to.
Okay. I saw on the screen that it said anybody who can file a thing as long as it's not a seasonal rental. Does that mean a complex that has HUD units and market units, would they still be able to do it if their rent increase would be a lot? They would, even though it's run by HUD, they would.
Anyone can file a complaint, but there's certain forms of affordable housing where it's based on people's income, like typically like Section 8 is 30% of someone's income, like certain public housing is 30%. Other affordable housing, there's income caps, but it's not really tied to your income. For the forms of affordable housing where your portion of the rent or your rent is like a percentage of your income, you can't change that formula. That's set
Right.
by federal law or, the state. But I don't know that this would happen in East Lyme, but just hypothetically, there can be situations where, tenants with Section 8 or in public housing can still make use of the Fair Rent Commission. One would be if there's problems with conditions in the apartment, if the housing authority isn't maintaining things, again, going back to the Fair Rent Commission also having a role in buttressing housing code enforcement. That could be useful there in lowering the rent or escrowing the rent until repairs are made.
How about
Okay,
the
now
people
I
that are
need
in
to
the
comment on that, because there's a part of that I think needs to be separated out. Public housing and Section 8, not the same thing at all. Public housing, federal public housing, a government agency is going to establish the rent. And what the tenant pays, there may be a formula by how much they pay of how that plays out. But that is a sort of situation where a government agency has preempted you, I think, from deciding what the rent's going to be. Section 8 is totally different, because federal government does not, the Section 8 program does not regulate anybody's rents. What it does is says, it makes a determination whether it's willing to provide a subsidy and a calculation of what the tenants share. But the rent is totally up to the landlord. You have full jurisdiction. If a complaint comes in from a tenant who has Section 8, or the equivalent program is called rental assistance program, it's a state program like that, you have jurisdiction to say that rent does not meet the standard for Fair Rent Commission and move it downward. What you don't have power to do is to say, well, instead of 30% of income the tenant's going to pay, I think this tenant should only have to pay 25%. You can't do that because other law overrides that decision. So as a practical matter, for a particular tenant, if the landlord raises the rent and it's within the Section 8 limits, for example, it's actually not going to change the tenant's share. And so there's probably, if the only complaint is about the rent, I guess the tenant could file a complaint, but it's not going to make a difference to the tenant ultimately. But let's say the landlord raises the rent to a point at which either the program would not allow them to use their subsidy because the rent's too high, or the program would require that they pay 100% of the amount above a certain market level, certain rent level, then that tenant is affected by that rent increase, and it would make a lot of sense for that tenant if they felt that it was an unfair rent, to file a complaint, because if you agreed with that and pulled that rent down, it might pull it back below a level which would keep their share down. So from our perspective, it's not preempted, because the federal government is not setting the rent. The landlord is setting the rent. But if it's a program in which the federal government actually sets the rent, then I don't think you have the power to override the federal setting of the rent.
How about the people that live in the market value ones?
They could
They can complain, and then a lot of, I don't exactly know what sort of affordable housing there is in
Well,
East Lyme, but
There's a place
Yeah.
that has, and it's not controlled rent. You have
Yeah.
to make a certain amount of money, but you can't make more
right.
than this, are the majority of the units. But then there's one market value in each little section that is not controlled by
that's-
anything, so they
Yeah.
can raise your rent.
That's probably a LIHTC property, which they can complain because their rent is not based on a percentage of income. It's just
No.
below market. And
Yes.
they could still do a complaint based on rental charges or a rent increase, and you could still lower rent. It's just that those ones where you can't change like that formula where it's like 30% of tenant's income.
Right.
So think of it this way. Let's say you have a property in which, so let's say 20% of the units have to be set aside for people below a certain income.
Right.
And that's going to mean that will result in there being some rule that says that the rent can't be more than a certain amount. But there's no rule that says it can't be less than that amount. As you don't, that somebody who's so whether you're dealing with the tenants in the units that in the income restricted units, or with the tenants in the market rate units, either way you have jurisdiction. Market rate you have jurisdiction because there's no regulation of the rent anyway. That's all a landlord decision. So you clearly can regulate that. But for the restricted units, unless there's a formula like 30% of income that must be applied, there's no reason that you wouldn't. You're lowering the rent because it's unfairly high. Would affect the tenants, how much the tenant is paying, and that's within your jurisdiction, and it's not prohibited federally, because all the feds did was to cap it at a certain maximum. That's at least I think that's our mutual view of how it would work.
And I would just share too, hopefully this will not happen here, but I know this has been an issue in Stamford and in some other communities where in these affordable apartments where, there's their rent or income limits, sometimes people have gotten fairly large rent increases of $300 a month, which is just a peculiarity of, a new landlord coming in, or, the maximum that the state allows you to charge in that area or the town changing a lot. So it does sometimes come up, and those are still cases you can take, and I know have been decided by the Stamford Fair Rent Commission as well.
Anything else?
That was my question.
Okay. Well, we wish you good luck.
Thank
Yes.
you very much.
Thank you so much for having us.
Thank you for
It's really
coming.
a pleasure.
Thank you for coming.
And we're, you know, we're available if you know, to either we could come back, or if the staff wants to inquire about something, you know, we're more than willing to try and help people think it through. But again, the decision's yours, and you know, we don't make any decisions for you, and that's your job. And I think you'll find that sometimes cases seem pretty easy, that something either strikes you as being fair and reasonable, and that the tenant really doesn't have much of a basis to complain, and you're going to find some that you all say this is something's not right about this, and we need to do something. And so that when you're in that second category, then together you're figuring out, okay, what seems to be the fairest thing to do, and it may take some discussion to figure that out. But I think, you know, you'll learn as you go as to what seems to be reasonable, and you may have individual differences in what you think is fair and equitable. I mean, that's the thing about, it's not just that a lot of there's a potential for individualization of the decisions, but you know, the commissioners are going to have their own minds on this, and not everybody's mind is going to be the same. My experience is that over time, people's minds on the commission grow closer together, and you tend to start, as you listen to each other in making decisions, you tend to start seeing things in similar ways, and which is what makes it possible. And sometimes you get decisions from the commission that are really what the parties should have gotten together and figured out themselves, but they couldn't, for whatever reason they didn't or they couldn't. And I think you can be pragmatic, and where there's a precondition that needs to be met, you can be very pragmatic in saying in controlling, using rent levels as a leverage to make sure preconditions get met. So,
Could I just ask one brief question? I happen to live at the apartment house where the 12 other complainants are. If the commission were to file on behalf of the tenants, how would that, excuse me, back up, assuming the rent increases were not the same fixed amount, nor were they the same percentage, how would that work? If we were to rule, well, the tenants have a good case, so this person, they can have a $300 increase, this person, they can afford a $700 increase, and $500, so on. Of course, it's not going to be a standard amount. How would that work?
well, if the decision whether to individualize, how to deal with individual differences,
Yeah.
is something that the commission, I think, needs to think about when you have multiple applicants coming in on the same issue. I think it is common, it's not unusual, that the common issue may be the main issue for balancing purposes. When the commission considers the various factors and weighs them, it's not, I think it's not at all unusual that the commission would end up deciding that given that everybody with different incomes is already paying the same amount, that the most sensible decision is to make the decision be about what the amount should be, and not individualized based on individual incomes. It's not that it's not a factor or up for consideration, but it may be that the commission, hearing the whole situation, comes to the conclusion the most sensible thing for us to do is to do essentially the same decision for all the applicants, because the commission's weighing, say, the size of the rent increase a lot more heavily than what any individual situation is, and so you end up with the same decision for everybody. So it could be that the commission decides to have a general decision, but maybe with making an exception for one or two particular cases. It's really up to the commission, but it wouldn't be unusual. people have lots of money can file a complaint with the commission, and they probably could afford a tripling of the rent. If they've got a great job, they're making lots of money, but the landlord has just raised the rent $1,000, and the commission might say, well, the size of the increase actually outweighs, as a factor in our mind, the individual tenant's ability to pay, and they might make a ruling that still tells the landlord they're going to have to lower that rent. That's what you're there to decide. You have to balance that. So in a multiple tenant situation where everybody's got the same situation, the commission might decide that the uniformity of a decision is the fairest for everybody.
Are they all 1 bedroom, 2 bedrooms? Are they all the same size?
I mean, again, a lot of times.
Because I know certain rent will be.
You may work as your starting ground. What is the current rent? If all the units are priced the same now, you may say, well, we don't think, to resolve this, we're not going to set different pricing levels for different units.
Right.
If some of the units, though, are like 2-bedroom units, are with more than a certain number of square feet or at one price now, before you've done anything, and the smaller ones are at a different price, then you might decide you're going to use a percentage and say, well, we'll allow 5% increase, which means you're going to preserve the differential that previously existed. You're not going to change that differential, but the dollar amounts will work out differently. Again, that's for the commission to decide what they think is fairest. But it certainly is not unusual when you have multiple tenants all starting at the same rent and a rent increase all being the same for all of them, to end up just making the decision that we're going to make the same decision as applied to all the units, even though we may have been offered some evidence of differing tenant incomes. But we see that as less important than kind of the uniformity.
Are all these 12s the same number of bedrooms and stuff?
No.
Do we know?
No.
They're all
Yeah.
different.
Well, I
Yeah,
would say with us here in a training session, I don't want to be training you to how to make a decision in any particular case,
No,
and so I think you should
I just wanted to know
hold off
what,
on talking about it as a
the
particular
difference
case.
in bedrooms, because I know most places will say a 1 bedroom is this amount and a 2 bedroom is.
Yeah, and that's fine. That would
So-
and then obviously that would justify improving different amounts for different kinds of units. I mean, in some sense, presumably somebody has already decided in the status quo to what extent the units are already uniformly priced versus. I mean, you may also discover that the tenants who've been there for different lengths of time may have different rents. It's not unusual
Right.
that landlords are reluctant to raise rents for tenants who've been there a long time. So again, you're going to have to figure it out. I don't think there's any clear answer.
I did have one more thing I wanted to share before we close out, which is I think something exciting that's happened with all of these new fair rent commissions and many of them being revived is that there's now a fair rent commission network that's being formed of staff. So Stacy has been to a meeting as well as commissioners. So there's been, I think, 3 or 4 meetings so far, and the idea is to rebuild something that used to exist during the earlier days of fair rent commissions, which is have a coalition of all of the fair rent commissions, so you all can be learning from each other, developing resources together, troubleshooting. So there will be more information about upcoming meetings, I'm sure, but just wanted to let you all know that that's available too.
Thank you.
And I have the link to the next meeting I can share with everyone if you're interested in participating.
And there's presentation that they did. Did you say that was available in a PDF?
Yes, we have. I sent
This
it.
presentation tonight?
Mm-hmm.
Yes, and I'm gonna share that. I have a lot of
Okay.
information to share with everyone.
Right,
And,
thank you.
we'll answer your questions about the size of the different apartments for the complaints that we have and things like that. So I'll get that out to everyone as soon as possible.
Thank you.
Okay, again,
Thank you.
Thank you for inviting us.
Thank you, Raymond.
Thank you for
For the
presentation.
training, yes.
So propose?
Mr. Chairman, I propose that we adjourn for the evening.
I have a second?
Third. Meeting
All in
adjourned.
favor?
Aye.
Aye.
Aye.